This CLE webinar explores the potential discrepancies and industry standards associated with perfecting UCC financing statements. We'll examine how to avoid filing mistakes, how to identify incorrect information that could cost you, and stress that importance of post-verification searches. So ultimately, through today's session, it's our goal that you leverage due diligence to better your knowledge and increase your value to your firm. Mandy and I are both serving, as Lydia said, in the Director of Operations positions for Capital Lien. Mandy oversees all research supervisors and coordinators in achieving the most timely and comprehensive results for our clients. She also serves on the UCC Education Committee for the National Public Record Retrievers Association, or NPRRA, providing industry insight to article revisions and research standards. Before her tenure with Capital Lien, Mandy gained critical due diligence experience as a legal assistant to a metro area firm, and prior to that as a records clerk maintaining important confidential records for Medtronic. She knows the pressures those in the legal industry face. Mandy is driven to streamline processes for legal clients to increase efficiency in hopes of reducing everyday stresses. I myself have been refining the art of client relations to the legal industry for nearly a decade, with degrees in both management and marketing in conjunction with an understanding of risk mitigation. I use these skills to get to the heart of solutions for clients nationwide. Understanding the needs of our teams and what the future will look like for the legal industry is an ongoing challenge and a passion. I pride myself on being a great communicator and working diligently to ensure client needs are served with the highest level of customer service and integrity. For nearly 3 decades, Capital Lien has provided due diligence in several different areas of the legal profession. Most of what we cover today comes from experience in providing definitive UCC information so those in the industry can make decisions with confidence. We'll start at a basic level, navigate through some of the revisions, take a look at the revised forms, and discuss what is needed for filing. Then we'll provide some insight on what constitutes a legal name for an individual, business, and trust names. Lastly, we'll bring to light some common mistakes we often see and end with some applicable search recommendations. So as you can see, we have an awful lot to touch on today, but we still want to save as much time for questions at the end as possible. That said, as you think of a question, please type it in the chat area so we can come back to it at the end. And if we don't have a chance to answer your question, our contact information is provided at the end of the webinar, so don't hesitate to reach out to Mandy or myself at any time. Most people in the industry know that the Uniform Commercial Code is the law governing various financial commercial transactions. A UCC essentially gives notice to the public that the secured party has an interest in the personal property of the debtor. A UCC lien usually results when a secured party lends money to a debtor and the debtor pledges collateral to the secured party or lender in exchange for the loan. They can be recorded on personal collateral such as equipment, inventory, accounts, or anything that holds value that's not normally deeded or titled, like an automobile, aircraft, boat, or real estate. Collateral such as crops and livestock are secured through a CNS filing in some states, which is a different type of lien. The Uniform Commercial Code has 11 substantive articles. The most important in regards to personal property is Article 9. This article controls how the personal property can function as collateral within a loan transaction. And the latest revision took effect on July 1st, 2013, and it recommended uniform language regarding secured transaction lien laws provided to all states. This was an effort to minimize confusion about definitions and how to be more consistent in applying the statutes. With that basic understanding, I'll now hand it off to Mandy for a deeper dive.
Thanks, Ryan. The way a secured party can protect their collateral is to ensure that they have done whatever is required to reduce potential risk in relation to the loan with the debtor. Typically, filing a UCC-1 financing statement is what is most commonly used to perfect secured interest in collateral. It's important to know that the creditor that files first on that personal property has first lien position. Any creditors that file after will be considered next in line unless the first UCC lapses or is properly terminated. Priority of a lien is determined by the date and time it is received at the Secretary of State's office. A few other types of methods of perfection other than filing UCC-1 are listed on this slide. Possession is one way to secure interest. This method is required for such things as money and stock. It can be utilized for collateral items as well, but it's less common. Another method is a control agreement, which is used for book entry stock, investment funds, and deposit accounts. And also in regards for collateral, such as vehicles, a lien can be recorded on the certificate of title. So what is a UCC-1 form? What's required when filing? These are the most common questions I get regarding this form. A UCC is also commonly known as a financing statement, and in regards to what's required, it's really quite simple. Only 3 things are needed: the debtor's legal name and address, the secured party's name and address, and lastly, the collateral being covered, which can be a very specific list of property, or it can be also a very generic blanket statement covering all the assets of the debtor. Keep in mind that UCCs do not require signatures, nor are they considered a legal document. This slide shows what the revised UCC-1 form looks like. If you're familiar with UCCs, you can see that this form has been slightly cleaned up as tax ID numbers are no longer accepted on the form, well, other than in North and South Dakota, which still require tax ID numbers. The revision also removed the fields for the state of organization, the type of organization, and organizational ID, as it was felt those fields were not useful anymore. The UCC-3 is what is recorded when a secured party needs to amend the original UCC-1. A few things that can be accomplished are continuing a UCC for another 5 years. You can terminate a UCC, and you can amend the parties or the collateral either by adding to it, deleting collateral, or restating the collateral completely. This form is also used when you need to assign the UCC to another secured party entirely. This slide just shows the revisions to the UCC-3 form. You can see that they moved the continuation checkbox underneath assignment box. On the last version of the amendment form, too many UCCs were actually inadvertently terminated when they were actually meant to be continued. So the thought process was if the boxes were not right next to each other, it would help reduce this error in filing. UCCs are typically recorded at the state level. And this is a chart that gives the name of each state's central filing office. Not all of them are called Secretary of State. For example, Wisconsin is called the Department of Financial Institutions, and Massachusetts is the Secretary of the Commonwealth. As usual, there are nuances and quirks of differing states and systems. For example, Florida requires a documentary stamp tax be paid on the value of the collateral. Tennessee requires a similar tax to be paid. Oddly, Wyoming's UCCs are good for 10 years instead of 5. Georgia and Louisiana both require their UCCs to be filed at the county level and are then shown in the central database. So, of course, the age-old joke applies of, like, what should be uniform is actually not uniform at all. But how do you know where to file? It's pretty easy to determine where to file if you're filing a UCC on an individual. The proper place would be to record that UCC in the state of the individual's principal residence. This would be the state on their active driver's license or active state ID. If you're filing a UCC on a business, you would file in the state in which that business was formed, which is not necessarily the state that they're physically conducting business. For example, if a company is registered in Delaware but does business in Minnesota, the statute requires the UCC be filed in the state of Delaware only, not in Minnesota, but in Delaware. I've seen many instances where the secured parties will file both UCCs in both states, but that's not necessary, although it's not harmful either. Finally, if you're filing on a trust, you would simply file in the state of the trustee's principal residence. Also, just a quick note about filing in Minnesota. Not sure how many of you are filing in our home state, but when you have to file a UCC in Minnesota, you have two options. One is to walk in a filing, and the other is to file online through the Minnesota website. However, if you happen to have an attachment on your UCC, you can only walk in a filing, as the state does not allow for attachments at this time. Not everyone wants to wait to mail or walk in that UCC, so keep in mind Capital Lien does have the ability to instantly file your UCC with attachments directly with the Minnesota Secretary of State. There's no waiting and no potential loss of lien position. Lots of states have been changing how they allow UCCs to be filed. For example, Colorado, Delaware, and New Jersey only allow for online filings and will no longer accept paper filings. So what I mentioned above is just in regards to Minnesota. Okay, so let's touch on some of the revisions that did go into effect. One of the revisions permitted each state to choose between two options regarding individual debtor names and what would be accepted as the quote-unquote legal name when filing UCC. Alternative A lays out that the legal name of the debtor will be exactly as it appears on the driver's license or state ID, as long as that ID is not expired. It also must have been issued by the state that you're filing in. So if the debtor has a license in Minnesota, you would file in Minnesota, not in Wisconsin. The majority of states have adopted Alternative A. Alternative B is not as straightforward. They allow for a few other ways to determine the legal name of the debtor. There are three ways to determine the legal name in this option. The first is similar to Alternative A, as the name stated on the driver's license or state ID. The second is the name of the individual under current law. And the third is the debtor's name, first and surname. If you're filing or searching in a state that has adopted Alternative B, you must search all three potential ways of filing against that debtor's name to ensure total due diligence. For example, say the debtor's name on the driver's license is Robert B. Smith. The name under current law is Robert Bradley Smith, and the first and surname is Robert Smith. A search would have to be conducted on all versions of that debtor to ensure all potential liens are revealed. Currently, there are 7 states that are Alternative B states: Arkansas, Colorado, Connecticut, Delaware, New Hampshire, Oregon, and Wyoming. Again, to reiterate, regardless of which option the state chose, the driver's license used must always be the most recently issued license. A state ID is equivalent to a driver's license in regards to UCC filings, and all ID cards must be unexpired to be a valid source of determining a legal debtor name. If you're unsure of which legal name to use, you can always file against multiple names on one UCC. For example, you can file against Robert Smith and Bob Smith as a second debtor. Anyone conducting or requesting UCC searches will need to still search all possible name variations until at least June 30th, 2018. An existing UCC that was filed under old rules will remain effective until the UCC either lapses or that date passes. One thing that is often overlooked is when a debtor moves out of state. When this happens, the secured party remains perfected in the new state for a grace period of 4 months after the date of relocation to that new state. During the 4-month period, the secured party absolutely should file an in lieu of filing in the new state of residence, which is just basically filing a new UCC1 in the new state, but they need to make mention in the collateral area that this is an in lieu of filing, and it should state the filing information of the original UCC in the old state. At times, some secured parties even attach the original UCC filing as an exhibit for reference. So what about trusts? Within the statutes, the definition of, quote, business organization includes business trusts and real estate investment trusts, because to form these types of trusts, a public organic record must be filed with the state. If the trust name is specified in the trust agreement, the name of the trust listed on that document is sufficient to use as the legal name of the trust when filing your UCC. Okay, so now we'll go through some of the more common filing mistakes. The two I see the most often in regards to filing UCC 1 are not filing on the legal name and incorrectly filing on the company's assumed name. As I just discussed, always file on the exact legal name of the debtor. Avoid using common nicknames when filing UCC. They will absolutely create a hidden lien. If you must file on a nickname, file on both the legal name and the nickname. So again, you would file on the debtor name of Robert Smith, and the second debtor would be Bob Smith. Here are a few case examples showing that the courts will hold a UCC seriously misleading if the UCC is not filed on the correct legal name. And that includes nicknames as well as spelling mistakes. In the first one, for Andrew Fuel, you can see the last name was spelled incorrectly with only one L. And the court determined that this UCC was ineffective because the name on the UCC did not meet the standard which required the full legal name. In the second case, you can see that the UCC was filed on the nickname of Mike Borden and not the full legal name of Michael Ray Borden. The courts also deemed this UCC ineffective because the state requires the legal name to be used when filing. A nickname does not meet this requirement. This is a very, very quick way to lose perfection in your secured collateral interest on your UCC. To abide by statutes, at the very minimum, you should be visiting the state's website to determine the legal name of an entity. Secondly, you should never include DBA or AKA or FKA as part of the name you're filing on. It will automatically become a hidden lien and will not be revealed in a certified UCC search that would be requested by a bankruptcy judge should your debtor happen to default. This slide is an image of a UCC, and it is an example of how not to file against a DBA name. The first debtor should be Good Dog Inc. and only Good Dog Inc. The second debtor should be separated out as the UPS Store 6160, and DBA should not be included in any part of the name at all. The best way to find out what the true and correct legal name is for a business is to pull the entity's organic articles and amendments and see what is on the actual documents. Many times, state indices can be inaccurate since they're all manually entered, so typos are possible. Also, if a debtor changes their name or address, the secured party needs to file a UCC 3 amendment to properly update and maintain their position. Now we will go over some of the common UCC 3 mistakes that are made. Over the years, I have seen a lot of combo or multi-purpose filings, incorrect original filing numbers used, and untimely filed continuations. One thing to remember when filing UCC 3, you always have to use the original UCC 1 number, not a previous UCC 3 number that may be associated with that original UCC 1. So a multi-purpose filing isn't exactly a mistake, and actually many states do allow for them. However, we do not recommend filing them as the state can miss part of what the secured party is trying to accomplish with that multi-action filing. The states that do allow for multi-action filings usually charge per action anyway, so you're safer filing each action on its own form. For instance, one form to continue the UCC, and a separate one to amend the collateral for that UCC. This is a screenshot from our database direct system. I pulled up an example of what can happen with a multi-action filing. You notice there was a filing on January 3rd, 2012, and another filing right afterwards on January 4th, 2012. This happened because the Minnesota Secretary of State missed that there was a second action to this UCC3 filing. One action was for a change to the secured party, and one action was for a change to the collateral. The original amendment had to be filed again on the 4th to make sure that the second action was captured. As you will see, the same form was recorded twice on 2 separate days to capture 2 different actions. Here's the January 3rd form, and here's the January 4th form. It's hard to see, but nothing about these forms changed. The state requires a filing for each action and missed the second action, so they basically filed the exact same form twice. If there was a separate form for each action, it would be clear what is happening with each amendment. If the secured party or filer was not paying attention, they would not realize that only part of what they were trying to do was accomplished and recorded at the state level. Another common mistake is attempting to file a UCC3 with the incorrect original UCC1 filing number. A few things can happen in this situation. First off, your filing can and will most likely be rejected, or at least be delayed in getting recorded until the correct filing number is determined. Secondly, if the wrong original number is used when filing a continuation, by the time the filing is rejected and then returned to you, the UCC could potentially have lapsed. If this happens, lien position is lost, and a new UCC1 needs to be filed because a lapsed UCC cannot be reinstated for any reason. Lastly, if you use the wrong original UCC numbers, you could potentially amend the wrong UCC filing altogether. For example, if you record a UCC3 and the number is off by even 1 digit, you could have just amended a completely different filing for a completely different secured party and debtor. The last common UCC3 mistake we will talk about is the untimely continuation. UCCs are good for 5 years typically. If they are to be effective for an additional 5 years, they need to have a continuation filed. There is a window to continue that opens 6 months prior to when the UCC lapses. This is the only time the UCC can be continued. Once the continuation is filed, the lapse date is extended 5 years from the previous lapse date. If you attempt to file too soon, the filing will be rejected, and there is a chance it may be forgotten about later when it's time to try to continue it again. The best way to know that you have successfully filed your UCC1 or UCC3 is by running a search to reflect. This is also known as the post-lien search. By running a search like this, you can double check to make sure that the filing itself is of record and indexed properly. It can also help verify your lien position relative to other creditors if applicable. And finally, it closes the gap between your pre-funding UCC search and the filing itself. We highly recommend conducting a search after any and all UCCs are filed. There are a few ways to accomplish a post-filing search. You can run a certified search on the exact legal name of the debtor. This uses the state standard search logic approved by IACA. The benefit of running a certified search is that if your UCC is unperfected or seriously misleading, it will not be revealed in this certified search. And you will know that you need to take action to correct it to maintain proper lien position, probably by filing a UCC3 amendment. You can also run a plain or uncertified UCC search. This search is much more common, usually less expensive, and at times the results can be returned faster as well. The benefit of running a non-certified UCC search is that you may potentially see name variations that you need to address. The downfall of this is that your UCC may be revealed in this type of search, but that does not guarantee that it will be revealed in a certified search. So that can give you a false sense of security. Lastly, at times, a secured party will simply run a filing number verification search. This is not a search on the debtor name at all, but on the UCC filing number only. This type of search allows you to see how the filing is indexed at the state level, which can be helpful to uncover typos and anything that may be misindexed. That sums up what I have to discuss today about UCCs. I will let Ryan lead us through the rest of the presentation.
Thanks, Mandy. So hopefully you all were able to pick up a few key pieces of information to help you in your ongoing work with UCCs. It always amazes me how small UCC issues can become large, costly problems. We see it often. Since we handle many UCC filing requests daily, we see a lot of the things that can go wrong for a secured party if the correct steps are not followed to get their UCC perfected. So along with the constant stream of UCC requests, one of the other most popular requests in the legal industry is for a 5-point adverse search. This involves obtaining UCCs, tax liens, judgments, pending civil and bankruptcy search results. In terms of jurisdictions, these are searched at the state level, county recorder, county courts, USDC, and the USBC accordingly. If needed, it's a good method to also request corporate documents to accompany a search of this nature, such as good standings and certified articles. Here's an example of the way we recommend a 5-point adverse search be formatted for your results. All pertinent result documents would follow behind a spreadsheet summary like this. Most paralegals and attorneys alike enjoy having this to serve as a quick reference prior to a loan closing. Regardless of what risk mitigation firm you entrust as a partner to your process, here's some things to keep in mind when filing UCCs and having research conducted. Do not put you or the firm in a bad situation by getting locked into a contract or a subscription. Seems like a good idea at the surface and with good intention, but you don't want to feel stuck with a certain provider, especially if their research is lacking true due diligence. And be wary of recurring costs that are not transparent. Also, inaccurate results can be an added liability and quite costly to your firm. Use a provider that has your best interest at heart and can continue to prove themselves to you over time without making you feel stuck. Also, there are over 4,000 jurisdictions nationally and an incredible amount of different skill sets involved to ensure the very best compliance in all of them. To know each nuance and be able to dedicate your time to them can be daunting, especially with your tight deadlines. Entrust a provider to be your behind-the-scenes resource, essentially, in regards to UCC filings and research. And the final thing I'll mention is E&O insurance. If you use a risk mitigation firm, verify that they can provide proof of having substantial E&O insurance. If they do not carry this type of insurance, then they might not be dependable in having the backing to consistently stand by their delivery of results to you. And the main thing to remember, you as the legal professional are the hero to your organization. Let us help make that happen. And I hope we have helped many of you today. So with that, we want to thank you for attending what we see as one of our very worthwhile CLEs, and we want to address some of your questions at this time. And again, I encourage all of you to email or call us as your needs arise down the road. Thank you.